In this video, I will try to explain some of the constitutional issues arising from Brexit, particularly issues relating to the structure of the government of the United Kingdom. I will then go on to discuss how that might affect the regions of England. I'll begin with the negotiations. It is primarily the responsibility of the United Kingdom government to negotiate the deal for leaving the European Union with the other 27 member states. Devolution adds complications to those negotiations because, of course, we have extensive devolution of power to institutions in Scotland, Wales and Northern Ireland. Parliament also has a major role to play, and it is now considering the European Union Withdrawal Bill. That bill does not deal with the negotiations themselves. It's primarily concerned with the consequences of Brexit for domestic law in the United Kingdom across the United Kingdom's three legal systems. If it is enacted in its current form, it will do four things. First, it will repeal the European Communities Act of 1972. Secondly, it will continue to enforce all existing laws in the United Kingdom which are derived from our membership of the European Union. Thirdly, it will confer extensive powers on government ministers to deal with the complexities that arise from Brexit. And fourthly, it will change the powers of the devolved governments and assemblies. The first point is simple. Much of our current law is derived from European Union law. The bill attempts to convert all of that law that is derived from EU law as it stands at the moment of exit into domestic law. Therefore, the laws should be the same immediately after Brexit as they were immediately before Brexit. And this is being done to ensure that there is no confusion about which laws apply after Brexit. And in order to do that, the bill creates a concept called retained European Union law, which is defined in more detail in the bill. This retained European Union law will in general continue to have effect after we leave the European Union, but legislation passed after exit day may change any rule of retained European Union law. That is what you would expect, because one of the main purposes of Brexit was to free the United Kingdom from the obligation to comply with European Union law. However, where a conflict arises after Brexit between a rule of retained European Union law and legislation passed before exit day, then the retained European Union law will prevail over the legislation. So, for example, after Brexit day, somebody might complain that a pre-Brexit piece of employment legislation failed to give adequate effect to the existing EU employment law. That challenge will still be possible after Brexit day because the previously European Union law will have been converted into retained European Union law. So in effect, the bill will create a new hierarchy within the United Kingdom's legal systems, and we will have to be able to distinguish both between legislation made before Brexit and legislation made after Brexit, and also distinguish between what is retained European Union law and what is ordinary law. The bill also says that the United Kingdom courts are no longer obliged to follow the decisions of the European Court of Justice after exit day. However, they will be permitted to take those decisions into account. So although decisions of the European Court of Justice will not be binding, they will remain relevant and they will continue to have an influence on UK law after Brexit day. As to the third point, ministers are given extensive power to make regulations in order to prevent or remedy or lessen problems arising from this attempt to convert European Union law into domestic law in the United Kingdom. They also have extensive powers to implement the withdrawal agreement, and in both cases the powers are exercised by regulations and include the power to change, alter, amend or repeal acts of Parliament. This is a constitutionally unusual power and it's known as the Henry VIII power. As to the fourth point, devolution, the United Kingdom government claims that the bill will maintain the current scope of devolved decision-making powers in those policy areas currently governed by European Union law. This is true, but perhaps not the whole story. The current position is that the devolved assemblies have got power to legislate in many policy areas, such as agriculture, fisheries and the environment, which are regulated to a significant degree by European Union law. So the devolved institutions can legislate in those areas, but they mustn't legislate in a way inconsistent with European Union law. For example, anything they do with farming subsidies has to be consistent with the common agricultural policy. The bill will take away this limitation based on European Union law in all the devolution legislation, but it will then replace it with a new limitation based on retained European Union law. And that means that the devolved assemblies will have no more freedom to legislate on, for example, agriculture, fisheries and the environment than they had before, but the constraint will be in a domestic statute, not in European Union law. And so, for example, neither the Scottish Parliament nor the National Assembly for Wales will be able to make much alteration to the law on farming subsidies after Brexit. Now, this too is controversial, and it was denounced by both the Scottish and Welsh governments as a power grab by Westminster. The United Kingdom government denies this. They say that this is a transitional arrangement which is necessary to give it time to work out those policy areas where a common UK framework is needed after Brexit, and that once that process is finished, they expect to be devolving back to the devolved institutions powers in those areas where we don't need common frameworks. Okay, now that's interesting because these provisions change the powers of the devolved institutions, and that means they engage the Sewell Convention. The Sewell Convention basically says that the Westminster Parliament should not legislate in any devolved policy area without the consent of the devolved assembly in question. Also, the UK government should not alter the powers of devolved institutions without the consent of the devolved assemblies in question. So there's no doubt that the European Union Withdrawal Bill does require the consent of the Scottish Parliament and the National Assembly for Wales. We have a difficulty with Northern Ireland at the moment because devolution there is suspended. As the Scottish and Welsh governments had criticised the bill as a power grab, there is the possibility of a constitutional crisis if they refuse consent to the bill. However, the recent rhetoric has been much less confrontational in tone, so it may be that a deal can be made between the UK government and the devolved governments, which averts any possible constitutional crisis. So what does all this mean for the north of England and for the regions of England generally? Well, many of the effects of Brexit will be felt throughout the UK, but particular regions may be particularly vulnerable to certain effects. For example, regions with a lot of manufacturing industry may find it particularly difficult being outside both the customs union and the single market. Professor Bailey's video, which is also on this website, discusses the issues facing the automotive industry. However, the way that Brexit will affect the regions of England, and in particular the north of England, also depends on the governance arrangements. And here we can draw a clear contrast between Scotland, Wales and Northern Ireland on the one hand, and the regions of England on the other. There is nothing approaching the devolution schemes for the other three nations for England and its regions. It's not just that the extent of power devolved is much less, it's also that there is not even a consistent approach to regional government in England. Over most of England, local authorities remain the key actors, but the position has become much more complicated in recent years through a process of giving additional power to local and regional bodies on an essentially ad hoc basis. For example, London has an elected assembly and a mayor and substantial powers. but no other region has an arrangement that directly matches this. Instead, there is a patchwork quilt with, in some parts of England, combined authorities grouping local authorities together, but not in other areas. And on top of that, there have been developed the so-called city devolution schemes. And all of these different schemes have varying powers devolved. In some cases, they have elected mayors, and in some cases, they have not. So without going into great detail, it is a very complicated system, arguably not a system at all. And there is concern whether this system, if it can be called a system, is the most effective set of arrangements for enabling the regions and the localities throughout England, but particularly in the north, to respond to the challenges of Brexit. Part of central government's planning for Brexit should involve how to assist the regions of England to respond to the effects of Brexit. And part of that ought to be considering whether the governance structures we have are up to that task.